This is Barry Zalma speaking for Claim School Incorporated's Zalma's Insurance Fraud Letter, Volume 26, Issue 17, for September 1, 2022. The newsletter takes approximately 25 pages in the Adobe PDF format and includes, among other things, an article about a public adjuster firm accused of pocketing over $600,000 in insurer payouts in 2 states. Andrew Joseph Mitchell, according to the Texas Department of Insurance, who reported that a public adjusting firm that was sanctioned last month by Louisiana regulators has pocketed more than $300,000 in insurer payouts intended for Texas property owners. The allegations against Mitchell include, on or about May 9, 2019, GZ and AZ's roof sustained damage. GZ and AZ retained Mitchell to represent them as the public insurance adjuster on their roof damage claim. Mitchell inspected the roof and provided an estimate. On June 21, one of Mitchell's employees filed a claim with QBE Insurance Corporation, also known as North Queensland Insurance Company Limited, on behalf of the insureds. On or about October 29, Mitchell received a settlement check for GZ and AZ's claim in the amount of $4,171.21, and Mitchell forged their signatures on the check and negotiated the check without remitting any funds to them. He did this multiple times, as listed in the article, including the fact that Louisiana also ordered Kate Austin Mitchell and Andrew Joseph Mitchell, a Texas father and son public adjusting team, to pay a $50,000 fine for pocketing money that was intended for insurance claimants. The department on August 18, 2022 revoked the public adjuster license to Cade and ordered him and his company Mitchell Adjusting to pay the fine after learning that no money had been refunded to clients as promised. The department also suspected a non-resident public adjuster license issued to Andrew Mitchell, so that both Mitchells no longer are licensed to practice in Louisiana. In addition, there's an article about why Michigan allowed a fraudster to collect PIP benefits, no-fault benefits, but was not allowed to collect UM and UIM benefits. The case, Jonathan Jones versus Homeowners Insurance Company, an August 18, 2022 decision of the Michigan Court of Appeals, dealt with an appeal from the trial court's order granting summary disposition in favor of defendants' Homeowners Insurance Company, American Country Insurance Company, and Hartford Accident and Indemnity Company with respect to plaintiffs' claims for uninsured and underinsured motorist benefits and first-party personal protection PIP benefits under the No-Fault Act. Although defendants disputed their priority to pay PIP benefits, the trial court did not decide the priority issue, but instead dismissed all claims on the basis of an anti-fraud provision in the defendants' respective policies. The case arose from a motor vehicle accident on October 28, 2017, in which the plaintiff's vehicle was struck by a vehicle driven by defendant Sharnetta Henderson in Detroit. Plaintiff alleged that he was operating a 2009 Ford Crown Victoria and was stopped at a red light when Henderson's vehicle, traveling at a high rate of speed, drove through a red light and struck his vehicle. Plaintiff sued all 3 insurers for recovery of the no-fault PIP benefits and also uninsured and underinsured motorist benefits. All 3 insurers filed motions for summary disposition, and they were granted. The Court of Appeal noted that although the trial court concluded that summary disposition was appropriate because of the anti-fraud provisions of the insurance policies, it failed to determine whether plaintiff was considered an insured for purposes of the policies, and whether any alleged fraud occurred to induce the policies as opposed to post-procurement fraud, and whether statutory or common law defenses were available in light of the fraud issue. Plaintiff's complaint and also included claims for UM and UIM coverage. They were part of the policy and subject to the fraud defense. However, the statutory requirement for no-fault benefits does not include, nor does it have, a fraud provision, and therefore he was entitled, even though he committed fraud, to a right to collect on his PIP benefits. The Michigan no-fault statute needs amendment, in my opinion, to provide a person with benefits if he or she commits fraud in the presentation of the claim. This case allowed the plaintiff to collect no-fault benefits even though his presentation of claim is clearly false and fraudulent. A trial to determine the extent of those PIP benefits because of the fraud will be interesting and probably very limited. Of course, since the fraud is so obvious, Plaintiff Jones should have been arrested, tried, and convicted for insurance fraud under the state's criminal statutes. Michigan Insurance Code sections 500.4503 and 4511 make it a felony to knowingly lie about or conceal an important fact in connection with an insurance claim. Then there's an article about the law applies to thee, but not to me. An insurance fraud pays for some reason in New York when a convicted school principal convicted of insurance fraud was still allowed to continue in her position as a school principal. Onetha Swinton, the former acting principal of Port Richmond High School in Staten Island, New York, was convicted of car insurance fraud, but she kept her employment with the New York Department of Education and even got a raise, despite what school investigators called her pattern of dishonesty. The entire article is available on my website, where you can link to this issue of Zalma's insurance fraud letter. Then there's an article about California claims regulations, which, if you have not trained your personnel by today, you're in violation of the Fair Claims Settlement Practices regulation, and you have until September 28th to fulfill the SIU regulations. There's a lengthy article on what must be done before electing to rescind, and every insurance professional, and especially fraud investigators, should be aware that before a party considers rescission of an insurance policy, whether by the insured or the insurer, the following must be established, regardless of the jurisdiction. 1. The facts represented in the acquisition of the policy. 2. Evidence that establishes whether a fact was misrepresented. 3. Evidence that establishes a material fact was concealed. 4. Evidence that establishes that the fact misrepresented or concealed was material to the decision to insure or not insure. 5. Evidence that the person seeking rescission did not have better knowledge of the facts claimed misrepresented or concealed. 6. A sworn declaration from the underwriter who made the decision to insure or not insure concerning the effect true facts would have had on the underwriting decision. 7. A review of the policy application process, investigation results, and applicable law by a competent insurance coverage lawyer in the jurisdiction where the policy was made to be performed. Next, a thorough investigation of the negotiations for the policy, and a sworn statement from the underwriter who made the decision. There's a lengthy article that explains the remedy of rescission. Then there's an article about why a New York state-wide senior action council announced its Medicare fraud of the month, and that one dealing with telemedicine. There's a listing of good news from the Coalition Against Insurance Fraud of the last 2 weeks' convictions for insurance fraud. There's a listing of health insurance fraud convictions reported over the last 2 weeks, with stories like how a South Bay chiropractor was sentenced to prison for receiving kickbacks, how Medical Fraud Division secured $650,000 settlement with Atlanta Behavior Medicine, how Mallinckrodt was required to pay more than $230 million to settle a lawsuit alleging underpayment of medical drug rebates, how a California Attorney General secured $70.7 million in settlements against the Southern California County Organized Health System, a story about a Lawrence, Kansas woman who was fined in order to repay more than $5,000 to the Kansas Medicaid program, and many, many more convictions reported in this issue of Zalma's insurance fraud letter. An article about how a Florida sting operation busted 13 contractors without workers' compensation, a schedule of other than health insurance fraud convictions, including a Florida staffing firm head who was sentenced to 24 years for an off-the-book labor scheme, about a Louisiana woman who pleaded guilty to FEMA fraud, how the wife of a pastor was sentenced for his 2021 murder-for-profit scheme, and how people who buy broken-down cars and use them in bogus claims, and how a Massachusetts contractor was sentenced for a $1.8 million payroll tax scheme, among many other fraud convictions. An article about insurance fraud in the UK, brought forward by the Association of British Insurers and the British Insurance Fraud Bureau, and stories about new books from Barry Zalma, me, which I hope you will purchase and find of interest. If you found this video and the article, the Zalma's Insurance Fraud Letter for September 1, 2022, to be of interest, please forward it to your colleagues and friends. It's free, and please ask them to subscribe. Thank you for your attention.